everyone. My name is Caio da Silva Pereira Neto. I'm a professor at FGV Direito SP, and I'm here with Professor Joseph Tringali from New York University, who is here with us this week to teach a short course on United States merger enforcement as part of our school's global law program. Joe Tringali is currently an adjunct professor at New York University Law School, as well as an adjunct professor at the Hong Kong University Faculty of Law. His expertise has led him to be recognized by Chambers USA in competition law. After 30 years of practice, he's a well-seasoned practitioner as well as a professor of law. So Joe, thank you very much for being with us this week.
Welcome.
It's a great pleasure to receive you at our school. And I'd like to start by hearing you a little bit about how the merger control system works in the US, what's its purpose, so that you can tell a little bit to the people that are not really familiar with this area.
Sure. So similar to many other countries, including Brazil, in the United States, if you meet certain tests, certain jurisdictional tests, we have in the United States a size of the transaction. It has to be a transaction above a certain amount, roughly $100 million, and a sufficient amount of assets and revenue in the United States. Then there's a mandatory filing with the government. In the United States, we actually have two agencies that have concurrent jurisdiction, which makes us somewhat unique in that regard, Federal Trade Commission and the Antitrust Division. And they, after you make this mandatory filing, they have 30 days to decide whether to clear the transaction and let you proceed, or to request additional information. And it's essentially what in Brazil would be the phase 1 and phase 2. And at the conclusion of their investigation, they will either close the investigation and allow you to close the transaction, or they will have to go to court. The agencies themselves cannot block a transaction in the United States. They have to go to court and get a court to rule after an evidentiary hearing, usually a trial of a few weeks, whether or not the transaction can proceed. And so that is the typical process. And these investigations, unlike other jurisdictions, which are much more limited in time, a second request in the United States is a very voluminous and time-consuming and expensive undertaking, and they can go on easily for 6 months and longer, quite frankly.
Sure. And what agencies are usually looking at and trying to assert is whether that transaction is going to reduce competition, whether there's going to be a substantial lessening of competition, right?
And typically, our law is that a transaction is illegal if it either substantially lessens competition or tends to create a monopoly. The substantial lessening of competition is really seen in two different ways. One is what we call coordinated effects, which is that it's an increasingly concentrated market, which makes coordination, collusive behavior, cartel-like behavior more likely, or unilateral conduct when you have two companies that are merging that are each other's closest competitor. So just by eliminating the competition between those two companies, you'll have an anti-competitive effect. And typically the anti-competitive effect, the principal one, is increased prices. There's also the possibility of a degradation in terms of quality or innovation, but pricing is typically what the government will focus on to see is there an anticipated price increase because of the reduction in competition, either coordinated because there's fewer players, or unilateral because they were each other's closest competitor and they were restraining prices to a larger extent than any other competitor in the market.
I understand, and it's a super interesting procedure as well as a deep analysis on this side. And also, I'd like to know, are there recent developments that we should know of? I mean, what happened in the Biden administration, how you look at the past few years, any big changes that you would highlight?
So in the Biden administration, we have merger guidelines in the United States. They're the ones that existed for a number of years. They came out in 2010 in the first Obama administration. They remained throughout the first Trump administration, and they remained for the first several years of the Biden administration. In December of 2023, they issued new guidelines. And this was the first time that they combined horizontal and vertical merger guidelines in the United States. One of the things a few things that were noteworthy. Number one is that the level of concentration was lowered, although quite frankly, as a practical matter, those levels of concentration are not the levels of concentration that the government typically will challenge a transaction. It tends to be much higher. But the Biden administration did lower the level of concentration. They also added for the first time labor markets as an issue of concern. In the past, you would often have a complaint that by the workers, the unions, or whatever of the company that's being acquired, that there's going to be layoffs. But that was never seen as a competition issue. But in the Biden administration, the way they looked at labor markets was to say, if these two companies, the competition between these two companies is causing a effect on wages, benefits, whatever, that the elimination of that might in fact cause for lower wages or decreased benefits. So that became a competition concern. So this was the first time that labor markets was seen as an issue of concern. They also, but no transaction was challenged on that basis, but they put that in the guidelines for the first time. They also were asking in an investigation on things like climate, to the extent that that was an issue of that was a matter of competition, and even DEI, diversity, equity, and inclusion, because those could be elements of competition between the companies.
I see. And any particular developments on tech mergers in Biden?
Yeah, so the Biden administration, particularly at the FTC, where the chair of the FTC was someone who had, before she's an academic, had written extensively with regard to the potential problem with big tech. Amazon was one that she focused on. So big tech was definitely a focus of the Biden administration because of the concern that there was so much power with these platforms, and they didn't want to have, even if there wasn't a traditional horizontal merger, all these add-ons were problematic. And so, for example, today there is a pending lawsuit against Meta. Facebook acquired both WhatsApp and Instagram. They were both cleared by the government years ago, and now they're seeking to divest them. So just because of the concern that platforms like that are now have too much power in terms of the information, personal information and the like that they're getting from now having people's personal data with regard to now on the Facebook platform, WhatsApp, and Instagram. Mm-hmm.
Sounds like very active years during the Biden administration.
Very, very active years.
Yeah. So, and what about now? I mean, we're just in a major change in the U.S. New administration comes up. Trump administration comes in with this America First policy very aggressively. How do you see merger control in this new scenario?
So before turning to America First, I think, and more neutral, I think that a Trump administration or Republican administration, I think there's two things that will be emphasized more than they were under the Biden administration. One is efficiencies. The Republican administrations tend to be more pro-business, and to the extent businesses are going to be more efficient, they see that as a good thing. So I think there'll be more attention paid to an efficiency defense. I don't think that's going to play out in court. I think that's going to be in the agency, because courts are bound by the law on efficiency defense, and the law on efficiency defense in the United States is very strict. But I do think that there will be much more receptivity at the agencies under a Trump administration to efficiencies. Secondly, the structural presumption that we have in the United States for mergers that increase concentration by a certain amount is something that's criticized by some economists, more conservative economists, as saying that that the underlying economics is actually outdated, and their argument is that the larger firms, the more concentrated markets, the fact that they may have higher profit margins is maybe a result of pro-competitive things, which is that they're more efficient, they're larger, they have scale economies and the like, and that you shouldn't penalize them in terms of a structural presumption. So that's sort of more neutral and just in terms of ideology. America First, I think the potential implications there that I can see happening is I can very well see, given what's going on today with tariffs and the like, and the emphasis on promoting American companies, is when an American company is acquiring a foreign company, I can see the merging parties, the American company, advocating to the agencies that this will make them a more competitive in other markets outside the United States, and that therefore the government should be more lenient towards whatever problems might exist in the United States in terms of competition, because they should focus more and give more weight to and recognize the benefit to having this American company being more competitive overseas. And conversely, I think that to the extent a foreign company is acquiring an American company, to the extent it's there's some basis, but not a case that necessarily would have been challenged. There's a possibility, at least, that it could be challenged now to the extent they want to keep the American company independent.
Mm-hmm. Yeah, and maybe looking at this from a global perspective, this could also lead to reactions from other jurisdictions, right? Like the EU or Brazil, like in promoting national or international champions that would be more competitive worldwide.
I mean, we're seeing this today, obviously, with tariffs. With if the retaliatory tariffs, people are not just going to sit back. So to the extent whether it's a Brazilian company, a European company, whatever, is denied the ability to acquire a U.S. company, then I think you probably will expect some response because people are not just going to allow the U.S. companies to make acquisitions and then not have them being able to make acquisitions that otherwise would have gone through. So there can be this sort of spiraling effect, which obviously we're seeing with tariffs. And you could see the same thing happening with regard to mergers.
Well, it looks like this area is going to keep being very active in the near future. It
is going to be very active, and I think there's what I'll call more neutral in terms of structural presumption and efficiency in the Trump administration, and then I think there's the one that's going to be the more controversial one, and the one that may have global implications if they try to incorporate America First into merger control approvals.
Thank you very much, Joe. This is very insightful, very good to have you here at our school and also to have this conversation with you.
Thank you.